On behalf of Vesta, I'd like to thank you for taking the time to join us today for this webinar concerning important information for you as a community board member as you navigate the COVID-19 waters. We're happy to be partnering today for this conversation with the law firm of McCabe Ronsman. McCabe Ronsman is a full-service law firm with 7 attorneys representing community associations throughout the state of Florida. It's my pleasure to introduce you to the 2 attorneys from McCabe Ronsman who will be facilitating our discussions today. First is Ed Ronsman. Ed is a partner and is board certified in condominium and plan development law. Ed has devoted his entire career to representing community associations throughout the state. The second attorney today is James Roche. He is also a partner with the firm representing community associations and developers. James focuses on general counsel legal services, as well as representing associations in contested litigation. Thank you, Ed and James, for your help during these extraordinary times. Now, without any further delay, I'd like to turn it over to Ed.
Thank you, Jim. We really appreciate it, and we appreciate Vesta for taking the lead on behalf of your communities and really wanting to set this seminar up and make sure that we can provide you with some information, and obviously have a lot of great resources that they will be able to help you throughout all this. We hope that we'll provide you with some useful information. The disclaimer that we always provide as attorneys is it can depend on your documents, it can depend on interpretation of the state statutes, and where we're going with this today is that we're in a little bit of uncharted territory. We'll be talking about, from a statutory standpoint, the emergency powers under there's the Homeowners Association Act, which is Chapter 720, Condo Act, which is 718, and the Cooperative Act, which is 719. The powers are largely the same, but as we'll go into a little bit later, they're actually written more with storm or natural disaster like property damage issues in mind. And so that's where we're a little bit in uncharted territory when we're dealing with a pandemic like we are right now. A little bit just about how the presentation is going to work today. If you all are attending, you should be able to see a Q&A button. What the Q&A button is, that's how we'll be able to take questions throughout all this. And so if you type in your question, it will pop up for us. Typically what we will do is we will answer it live. Jim may be able to answer some Vesta questions by a written response, and you'll get that. But that would be the best way to ask us any questions. We'll try to get to all of them. If I see them come up throughout, and if it's kind of tied to what we're talking about, I'll try to answer it. Otherwise, we'll wait to the end. But that's our way to make sure that we take some of your questions. I also have received some good questions from you in advance of this a lot of them are pretty similar in nature in terms of especially geared towards either holding your meetings or what should we do with our common areas and amenities. And so I'll make sure we're going to be addressing that throughout the PowerPoint too. This is also being recorded, just so everybody's aware of. This will be used later on. Vesta will be able to provide it for people who couldn't attend today. So just if you see that, that's what's going on right now. So I'm going to go ahead and share our PowerPoint, and we'll go ahead and get started here. So the main topics we'll be talking about today, talking about the association's responsibility regarding COVID-19 and operating common areas and facilities. We'll talk about altering, postponing, or canceling community events and meetings, updating cleaning and maintenance schedules, planning for the possibility of shelter-in-place orders, or if there's already in existence, what do we do as a community association? And then finally, assessments and financial difficulties. And we see that as kind of the long-term effects for your community. Once we get through this from everybody knows about flattening the curve. And if we get through that, whatever that time period is going to be, where eventually this will die down through social distancing and all the other measures we're trying to put into effect. What's going to happen though is obviously everybody's seen the economic impact this will have with the stimulus bill coming out, people in various industries having more difficulties, of course, in keeping their job. That's going to affect your community association because some people aren't going to be able to continue to pay their assessments, most likely. Kind of akin to the housing crisis that we had with the downturn starting in around 2008 through really 2011. That's a different animal than what we have, but we could foresee some of that coming back, and some of the things that we've learned from that hopefully will help us for what appears to be a potential recession coming up and how that's going to affect your association. So some of the responsibilities during COVID-19, the role of the board generally is to oversee the maintenance, replacement, and repair of the common areas and facilities and the condominium common elements. So that's a general duty and obligation and a right under the governing documents for your community. However, the question is, how far do those responsibilities go when we have a pandemic that's going on right now? We've seen how it appears to be much more contagious, for example, than even the flu from what you see, depending on what sources you're looking at. But obviously, this is a highly contagious event, and we don't have anything right now in terms of a vaccine or anything to stem that from what we can tell. And so what is our obligation as an association in terms of the common areas and the facilities? It's a question that we've been receiving the most throughout the last couple of weeks, right, Jim? I mean, in terms of what should we do with our common areas? And so the question then is, how far do we extend? Does the association have the ability to take further action, to increase its cleaning schedules, for example, to take certain actions regarding the common areas and facilities that might be somewhat preventative, or at least trying to stem people from using those areas? And generally what we've been saying is I think that those are reasonable steps for the association to take if they choose to do that. But what you're going to hear from us a lot today, and we might sound like a broken record, but really is almost like disclaimer language as to advising the owners that it is not the association's job to prevent the spread of the illness or this disease. It's not, we are not actively out there, you know, I keep using this example of spraying down the door handles and the gates and pool, you know, the pool furniture and that kind of thing after everybody uses it. That's not the association's job. And if communications are going out that are saying something along the lines of, we are committed to your health and safety and welfare, we are committed to making sure that we protect you, that sets the stage for associations to incur some liability if, for example, somebody contracts the disease and they were using an amenity or a common element, and if they, now proof is a difficult issue on that. And so it's one thing for them to allege it, it's another thing for them to be able to prove it. But if they can show that the community was somehow stating that it was attempting to prevent it and it was unable to do so, the association may have unknowingly taken on a duty and a liability, essentially, for somebody that might get sick from this. Now, again, proof is a difficult thing, but if you've ever worked with an attorney before, what we always say is you can be sued for anything at any time. Whether or not you're successfully sued is another matter, but any personal injury attorney knows that an association, you're likely going to have insurance that will come in and pick up and make it a more viable claim. So what we're trying to do is to potentially limit the any liability the association may have. You can't prevent that from happening. You can't prevent a lawsuit from being filed. We're trying to take certain steps from our communications to reduce the association's risk. So Jim, did you want to talk about that a little bit?
Yeah, just to piggyback on that. So, you know, generally landowners, anyone who owns property in the state of Florida, they have duties to people that come on their property. And just generally speaking, you know, your duty to a trespasser isn't as high as it is for duties to people who have the right to be on those areas, right? And it'll be interesting to see how courts deal with, you know, defining the nature of an association or property owner's duty as it pertains to prevention of disease spreading and things like that. So we're in a little bit of uncharted territory, but what we're suggesting is, you know, if while you're communicating to residents, which is a good idea to do, be careful of saying things that could be argued by a personal injury attorney, you know, who's trying to potentially recover money for someone who's been harmed or his or her family. Try to do, you know, don't say things in a way that's going to make that case easier. You know, don't say we're committed to ensuring your health and safety. Don't say, you know, we're undertaking a duty to do this, right? That's what we're trying to say. And in terms of, you know, being potentially held liable and proof issues, you know, being able to prove where you contracted the disease is going to be very difficult for someone. But, you know, even if your case is relatively tenuous, even being sued is going to cost you money, and attorneys are going to know that, right? So it's not a matter of if it's going to cost you, you know, a certain amount of money. It's kind of how much, right? So, and in terms of insurance coverage, you know, many insurance policies have broad exclusions for pollutants, and pollutants is a defined term in many policies. And it's not just, you know, smog or something like that, or toxic waste. Pollutants is a very broadly defined term. So whether you have insurance coverage for, you know, an allegation that someone became sick on your property, that's going to be another struggle that we might face. So the bottom line is, let's try to mitigate things to the extent we can. And doing so, let's try to not communicate things to people that could be argued to say that you've undertaken a duty to protect people.
Jim, do you want to, this is a good question, the first question that just came up, and I think it would be a good time for us to maybe talk about this, and it might answer some questions that people may have. The question is if returning members from hotspots are flagrantly not practicing self-quarantine, does the association have an obligation to report them to the CDC?
So I think that question can be addressed in a couple different ways. First, from a more general standpoint, it kind of goes back to what are the general nature of the association's obligations in this situation. So first of all, what we're trying to discourage is, you know, don't become the police. So don't personally confront people who you believe are, you know, violating recommendations or in fact mandates. Law enforcement enforces law. If you believe someone's violating an executive order, an emergency order, something like that, call law enforcement to remove yourself from that confrontation, not only for your personal safety, but also, you know, to give that job to someone who has that job, and frankly, who's covered by sovereign immunity for the actions they may take, right? Law enforcement. So, you know, I think you can. I think you have the ability to report people, but try to be equivocal, right? And this also goes to in terms of communicating with your membership. If you're communicating with your membership about the fact that someone may have been exposed, right? It's unlikely that you're going to have a positive test result from that person. They're going to walk in and hand that to you, right? So you're going to hear that information from other sources. It's going to be hearsay information. So you want to be careful not to accuse someone of having a disease, because that could potentially be actionable defamation. But you also, it is a good idea to inform your membership of that. So just communicate generally. Don't identify personally identifying information. Don't say John Smith has COVID. Just say, you know, we've been made aware that someone in our community may have been exposed to the disease, right? And try to be more general. And also, whether you report that to, you know, law enforcement or other agencies, the Florida Department of Health or whomever, I think you can. I think you similarly be careful in how you communicate that. So now, whether you have the obligation to do that, that's something that could be argued. There's nothing saying conclusively that you do have that obligation. But even if you're not obligated, I think you could consider doing that. So to directly answer your question, it's uncertain whether you have that obligation, because again, we're dealing with that a bit of an unprecedented situation here. So do you have an obligation? Probably not, but there's an argument. So I would say consider doing it, but also don't be the police force for your community.
Yeah. And I see there's some good questions that have just come up that I think we can address on the common area and element operation. So to let you know where we're coming from, and Jim and I have discussed this a lot, even outside of the scope of this webinar, is the emergency powers that everybody's relying on right now. I have this up for condominiums and HOAs. That's the vast majority in the state. I can provide that if you need it upon request for co-ops, which is Chapter 719. It's a very similar, if not identical. Typically, the co-ops follow the condo forms, but all of these emergency powers are almost identical. That's where we're referring to. So you have a state of emergency that was declared, I believe it was on March 9th by the governor. That triggers then these emergency powers. There was something, there was some confusion, or at least debate in terms of the text of the statutes, which talks about damage to property. And really, you don't have any property that's necessarily been damaged so far, so much as it has been that, obviously, we don't want people gathering. We want to practice social distancing. And the Division of Condominiums, Timeshares, and Mobile Homes, they've come out and basically interpreted, they've issued an order saying that it is their position that the emergency powers apply, notwithstanding the property damage language. I think they even said that they're suspending the property damage requirement, which kind of means that they realize that the statute isn't perfectly written right now, which will most likely result in a change in the next legislative session. I'm almost positive to modify this. Now, you know, you write a law a certain way because in Florida, we're used to having hurricanes. That's probably 90% of what the focus is for the emergency powers under the statute. Of course, there could also be spot tornadoes or something like that, or any other type of a natural disaster, but it really is more related to property damage. I think we'll see an amendment to it where it will remove that property damage requirement. So that's the first thing that you look at. And so when it comes to common area and common element operation, there's a couple of provisions in the statute that talk about if you rely upon an emergency management official or from some type of retained professional. And we have that on the next slide here. Those are the two ways that the association can determine any portion of the association property unavailable for entry or occupancy, or whether or not the property can be safely inhabited or occupied. So the first point really might be more towards the common areas and amenities. The second part may be more towards if people can come back to their homes or their condominium units, for example. Habitation, you're almost like, it's the opposite here, where we want people to stay inside their units is what we're really asking people to do right now. So I think, though, that it's the first point that it's really giving grounds for us to take a look at this and what actions the association may take. It's really difficult for attorneys to tell you whether or not you should or shouldn't close down your pool or your amenities. It's a difficult question because you're kind of, damned if you do and damned if you don't, basically, from the standpoint of, if you close down everything, you're going to have angry residents that are probably thinking, hey, I'm here, I don't have anywhere else to go, I pay assessments to be able to use these amenities, and it's an open air pool, for example. Why am I not able to use this if I can practice social distancing and there's nothing showing that it's spreading through the swimming pool, for example? I don't know that we have that evidence yet that if you're in the pool, there may be some evidence. I don't want to misstate that, but generally speaking, you may have owners that are saying, I pay for these amenities, why can't I use them? So from that standpoint, if you close everything down, you may have challenges, and you may have an argument that, well, it looks like you're getting really involved in preventing people and trying to prevent the spread of this by closing down the amenities. Have you now undertaken that duty that Jim and I were just talking about, which is to any area that you're traversing, whether it's an elevator, wiping down the elevator buttons, are you supposed to wipe down the handrails going upstairs, for example? So there's no perfect answer for it. On the opposite end, if you keep everything open, and then somebody gets sick, could somebody argue that the association should have closed this down because they know it's an area that people are congregating? There's no perfect answer for it. But by and large, what I've been telling clients, and I think Jim and I have talked about this, which is it's a lot easier to close down the clubhouse, any more of a closed room, like a fitness center, a sauna, something like that, where it's much more of a closed space, where it'd be very difficult to practice the social distancing and not keep having people close together, or if surfaces are likely to be touched a lot, like if you're talking about a treadmill or weights or something like that. That's an easier decision, I think, to make, to close those down. And I think it's in line with a lot of the directives we've seen from the state and local governments, from closing down fitness centers and that kind of thing. Where it's more difficult is if you're closing down an open air pool, for example. And that's the tougher question that we have, because it could be a way for people to be smart and stay apart from each other. And people feel like that's kind of our last amenity that we have. Beaches are closing down all across the state. If you're on an oceanfront or a waterfront type community, there's not much else for people to do. I can understand that people are upset, but at this time, at least from a statewide level, there hasn't been a directive to close down pools. I have seen it. I know we were just talking about, and I don't think we have anybody from Miami in here yet, but I think I saw that Miami-Dade has basically they've closed down any public or private pool except for anything for a single family residence or a townhome that might have their own little hot tub that's only for individual use. There's some language in there that basically either recommends or mandates. I have to look at it some more. And so that is more specific direction coming from a local municipality that the association would have to look at. But from a state level, there's nothing saying that pools should close down, for example. So it just depends on your community. And what I would strongly recommend, though, is whatever action you take, work with your manager and your association council, because I think that communication is going to be key. And how you're communicating that to your residents, and also the way that you're making that decision, whether or not you can, for example, if an order comes out and you feel like you need to react to it, and maybe the president has talked to the attorney and it requires some type of immediate compliance, assuming that the mandate is lawful, for example, we could see a president making that decision, but then having a board meeting to further discuss it and ratify it so that the whole board is on the same page with it. So again, I think that for all of this, it's communication and it's thoughtful decision making for your community, and understanding that there is no right or wrong answer, a black and white answer that we can tell you, you should close this, you shouldn't close that. Go ahead, Jim.
Yeah, I want to add some takeaways to that. So we're not going to tell you whether you should close all of your amenities. It's going to depend on your community, how large it is, you know, how many people are using things at the same time, what type of amenity is. But what we will tell you is that if you do decide to close it, we do, depending on what your amenity is, we think that position will be defensible under our circumstances, okay? And some of you might be worried about, well, you know, what about the owner who's going to complain? Are they going to sue me personally for being part of the decision-making process and closing things down? And so most of you, if not all of you, are going to be part of directors of a not-for-profit corporation. And in the state of Florida, it's very difficult to hold personal directors personally liable for decisions they make on behalf of a not-for-profit corporation. So I think your exposure to personal liability for making these tough decisions that you're going to have to make is going to be very low, extremely low. And part of what courts look at if those decisions are challenged are not necessarily what the decision is made. They don't want a Monday morning quarterback the board's decisions, but what they will look into is how they made that decision and decision-making process. And that's part of the business judgment analysis. So if you're relying on professionals, if you're relying on local government, either recommendations or mandates, those are going to be things that are going to be considered in, you know, how you made your decision. So another thing is, while we don't presently have a statewide mandate on closing down certain amenities, so you do have local governments that also have authority to issue emergency orders and, you know, promulgate law generally. So you're going to have to look at your local jurisdiction and what it's doing as well, and whether it's phrasing its orders in terms of recommendations or actual mandates. So depending on where you are geographically in the state, you know, you might have to close down your pool if that is what the local mandate is, unless you know, perhaps want to make a constitutional challenge to that. But, you know, I would say that if you're relying on those, you're going to be, you know, protected from a personal liability standpoint, and your decisions are going to be subject to a business judgment rule. So, you know, a lot of this is try to make the best common sense decision that you believe is right for your community. And we think whatever decision you make is going to be something that's defensible in terms of closing it or limiting access to your amenities. So, you know, and it's not a binary issue, right? You can take some steps before outright closing an amenity if you don't think it's necessary at this time. So maybe you pass a rule, or you post a notice saying, hey, look, no more than 20 people are able to use this pool at this time, and it's limited to 2 hours per family or something like that, right? So you can do something short of outright cutting it off. But if you feel like people aren't really complying with that, then maybe you take the next step of shutting it down.
Yeah. So there's a couple questions. I want to answer them quickly here because we're kind of on this topic. One question is, our community has an open pool situation. Signs indicate only community residents allowed. We have seen people using our pool that are in violation of this directive. Do we have any recourse? So I think there's two ways to, I might need some clarification on the question, but I think I could see this two ways. One, if you're differentiating between only residents but not their guests, or if you have tenants, for example, that might be difficult. If you have people that are lawfully able to be there, it's kind of a difficult thing to close it down to people that might otherwise have an ability to use it. Typically, your documents say that any tenants have the same rights to use the common areas as the owners may have. So if you're differentiating between, you know, owners versus tenants, that could be problematic from an enforcement standpoint. But if you're going from a trespassing standpoint, contact law enforcement right away. If it's somebody that doesn't have a lawful ability to be in your community, contact law enforcement. As Jim said before, don't try to interject yourself and physically try to keep people. I know probably most of you wouldn't want to do that anyways, but contact law enforcement. If they have some type of a way of saying, well, I'm a guest here, or I'm a relative of a tenant and they invited me over, law enforcement may say, well, this is more of a civil issue. I don't know if it's trespassing. Then we have to deal with it later. But this kind of leads into the discussion of where we're at with the courts. In some circumstances, under normal circumstances, we may have been able to file for an injunction and get a hearing in front of a judge. Right now, almost all courts are basically closed down to only, I forgot what is it, essential functions?
Yeah, like
basically?
essential and critical functions.
Essential and critical functions, which 95% is related to criminal hearings. You know, so we're really not able to get in front of judges right now. So in terms of an actual step we're able to take to prevent somebody by way of a court order, it's really difficult for us to do right now. If the board is looking at maybe adopting rules, that may be grounds to do that. If you're trying to adopt a rule that's in line with maybe some of the state mandates or something like that, or something that's more optional for your community, that may be a way to have a meeting, pass more restrictive rules for the time being, and then if somebody violates that, then they could be subject to a fine after we're done, and you kind of, you know, there's a pocketbook aspect to it. but really there's not a way to physically prevent them if law enforcement won't do it. But look, I don't think that it hurts to call them and see if they'll come out and at least talk to people and say, hey, just be smart here, right? You guys are all congregating. You guys know this isn't safe. And maybe just having law enforcement coming out will at least spread the message practically. Whether or not they'll legally require them and actually physically require them to vacate is another thing. So I would not try to take it in your own hands. I would contact law enforcement as best you can. Another question is, if an order comes out to close the open air pools, how will the board be notified? Obviously, everybody wants to stay on top. You know, everybody's watching the news. We're all at home more, or everybody's staying in touch with either with it's Twitter or watching CNN or Fox News or whatever your outlet of choice is. But this stuff is being conveyed, and working with a great management company like Vesta, I know that they're on top, and there are great managers in the different areas are notifying you. And then work with your attorney too. Or if you see something that comes out, work with your legal counsel to see how this affects your community. Jim has mentioned a little bit. You touched on it. You might have a community, you might have a board that doesn't want to close something down, and you might have a directive that comes out from your municipality, and there may be questions as enforceability as to that. You know, you should bring that up to your attorney if you decide to keep it open, for example. So we're all in kind of it's touch and go a little bit right now. We don't have a specific directive on what should or shouldn't be open, and you've got different thing coming from the federal government versus the state versus the local government. So we're all trying to kind of synthesize that and figure out what's best for your community.
Yeah, we're seeing lots of sources of authority, and all of them are, there's an official way that the government, whichever it's, whether it's a state government or local government or an administrative agency, has to publish the orders or the rules that it's making, right? And depending on what it is, it's published in a different location. So practically, legally speaking, there's a specific place where that information is made public. From a practical standpoint, a lot of people are staying on top of this, particularly, your management company. So you're going to be notified if something like that happens and you need to, potentially consider action on it.
And I think we talked about this, but another question that, again, understandably comes up is communication to residents. What should the HOA communicate if there's a positive cases? We would strongly recommend against naming anybody without them, at a minimum, providing there's a question, what if they provide written permission to share their name? I would at least require that, but if they provide that to you and say, hey, I have this and I was out at the pool and we were practicing social distancing, but I don't mind you using my name, I would at a minimum require that before you would send out any type of communication on it. If you don't have that, I wouldn't share a name. The best that I would do is say, hey, we've been notified that there's a confirmed case due to privacy issues. We cannot name that individual, but please remember to practice social distancing. Here's some resources for you from the CDC and from our state of Florida, whatever it is, and you can point them to information on best practices for how to spot symptoms, how to prevent the spread, that sort of thing. But I wouldn't go further than that and name anybody if they haven't given you written permission to do so. All right. And I'm going to go ahead and just kind of continue on. I know we have some good questions here, and I'll make sure to jump back to them later on. Going into, we talked about restriction of common area and amenity use, case-by-case basis, many factors to consider: the health and safety of the residents, potential liability, and the rights and owners of guests to use the amenities. It's a tough question. And again, we try to give you some advice here, but you may need to, for your specific community, talk with your manager and talk with your legal counsel, depending on what decision you make and how that's being communicated in writing to everybody. So communication with residents, we've talked about this. Consider some type of an e-newsletter or an email blast with the status of the property and the amenities. So at least people, you're communicating to them what's open, what's not, what the association is doing with all this. Again, advise the owners and the guests that the association does not guarantee the health, safety, and welfare, and that any use of the areas that are open, or if there's walkways or something like that, of course, that you wouldn't close down, is at their own risk. The last point, though, and this is what we've been advising our clients, is you need to continue to have board meetings, and notice can be provided by alternative means. That's in the emergency powers for the different statutes for the condos, HOAs, and co-ops. Basically, what that says is that you have to continue having meetings, but you can give notice in a manner as practicable as possible. Again, the contemplation for that was if you had some type of a damage event, like let's say if a hurricane came through or there's a tornado and now it's passed through and the board wants to meet and they don't want to wait 48 hours, which you normally would have to provide for notice, the statute contemplates that you would give, hey, it's 8 o'clock in the morning. We as a board agree that we need to have a meeting this afternoon. you're allowed to provide that notice as long as it's provided to the membership. If you email blast or whatever, you can provide that short notice. For something like this with the pandemic, it's a little bit different because you're not really dealing with, you know, whether or not you're making a game time decision for damaged property if it's unsafe for people to use. Although there is that argument, right? Because of people could have been using it, and maybe you have a directive that came out from like the state or the federal government or from a local municipality. So if you have an order that comes out that maybe the board wants to act on it because you feel like, you know, you need to get advice from legal counsel and that it applies to you and you need to make a decision, that statute allows you to provide notice for an amount of time as practical as possible, but you still should provide notice. And that goes into the next really point that we have on the slide, which is board and membership meetings. So the emergency powers just talk about the way that the notice is provided and how much time really. It doesn't say the manner in which you should be providing meetings. So I think that it was contemplated, again, under the property damage side, that if you're able to meet as a board and there's some space that you have that people can show up if possible, or at least that they can attend and listen to a telephone conference, the board could make that decision from a safety standpoint. For this, we don't want people showing up. We don't want people congregating. Even Jim and I are almost where I need to move my chair back a little bit on this, right? But for the most part, I mean, many of you, if you can see our conference room here, this is the type of room that you'd probably be meeting in if you're a board or if, depending on the size of your community. And so what we've been advising clients is I think it's defensible if the association were to provide notice and make it a completely telephonic or virtual meeting. Again, that's not in the statute, but I think that it's defensible because there isn't a physical way for you to have it to comply with the 10 people or less from a gathering standpoint, 6 feet social distancing. Most likely you don't have a way to comply with that. And so I feel better about the board trying to conduct business and doing it in a way that's open in front of the membership where they can at least participate, even if it's not physically at a location, that they can call in and listen to the board discussing what's going on and their decision making for it, and then having an ability to comment on it. Where I'd be careful is if the board is communicating and voting on things by email for things that should be done at an open board meeting. So it's a reminder that you should still be considering having meetings if you are having business that needs to be conducted by the board. But you know, you may talk to 10 different attorneys, we may give you 10 different answers on this, but I think that it's defensible to have a completely virtual meeting where you post the notice and you email blast it out saying, hey, due to everything and the recommendations going on, there isn't a place for you to physically show up, but here's the telephone conference number. We will make sure that we can have the capability to have all of our owners on there and be able to listen and then comment on an agenda item.
And as a little bit of a qualification of that, we're primarily talking about board meetings because you need to make decisions about things, you know, irrespective of whether there's a virus issue, right? With respect to membership meetings, you know, I think, is there a way that we could guide you through, or your counsel could guide you through a process that, you know, we could at least defensively argue that is technically compliant with the statute? Sure. But is it worth, you know, it'll be a little bit of a cumbersome process to try to do that. So, you know, rather than try to figure out how you can hold your membership meeting and election, for example, I tend to think that the best thing to do right now for your membership meetings and elections is to just postpone them for now until the dust settles, so to speak. So, you know, I think you'll get a little bit of flexibility and maybe get a little bit of a pass if someone wants to challenge how the board is making decisions during this difficult time. But so long as you try to provide a reasonable opportunity for people to participate. But membership meetings, unless there's really something you absolutely have to do, communicate with your attorney about that. But probably the best thing to do on those is let's put those off for now. Let's focus on board meetings and the critical issues we need to address now. The annual meeting and election, we'll be able to have that, but let's, you know, perhaps put a pause on that for now is what I would suggest, rather than trying to come up with some cumbersome processes to, you know, technically argue that we've complied with statutory requirements there. Because again, like Ed said, what the emergency powers don't do, to the extent that they apply, is allow us to derogate from, you know, things like how we're holding annual meetings and elections. And I think we might see some changes in the future on that, but right now there are a little bit of limitations on what we can do. So let's put off membership meetings, let's hold board meetings. And if someone wants to challenge it, of course, we have the strategy of being able to ratify the actions that you previously taken on the back end. So there are some things that we can do to tidy up things on the back end as well.
Right. So going in, so we talked about the difference between board and annual meetings. Let's see, going into membership meetings, maybe cancel and reschedule. And let's talk about the postponing the postponing aspect. And so if we've had a lot of questions on if you have your annual, a lot of you have your annual meetings in the spring, for example, and we've had a lot of questions about, well, we have our meeting, it was set for April, and we've sent out the first notice, but now we've got this, and of course we want to postpone or cancel it. What's the best way for us to do that? That Jim and I have talked about this, and there's some interpretation involved with the statute as well on it. I am of the position, and I think, again, you're talking about if it's defensible. I think it's very defensible if the association said, hey, we would normally send out our second notice. This is primarily geared towards our condos and our co-ops that have the kind of the two notice election process that you're required to do. HOAs, if you've done this, or if you have it in your bylaws where you have a two-step process where you maybe send out your first notice, call for candidates, and then the second notice goes out with the candidates that have submitted their name on time and the ballot and everything. It's that middle period where you're between your first notice and your second notice. What a lot of our communities have done are they're not holding their meetings in April. And then the question is, do we have to start over again with the first notice, or can we postpone it and then send out our second notice at a later date? I think the more conservative approach, of course, I think that because of the emergency powers in the statutes that the membership meetings may be canceled and rescheduled. I think the canceling part shows that I think that you could cancel it and then start over. The difficulties with that are you might have somebody that didn't get their name in on the first time, but now they have an opportunity now to submit their name for the board. And we all have been part of this where there's some politicking that goes on with running for the board and there being a time period. And so I can see some difficulties with that, and just the administrative function of now having to start over, and there's a cost for it, especially if you're in a larger association where it's not cheap to do the annual meeting notices and everything. So to start that over, I get, even from a practical or a cost standpoint, might not be preferable. The suspending, I'm sorry, for the postponing of the meeting, I have advised some of our clients that have asked that I think that is defensible, where you would essentially send out communication saying, we've sent out the notice, we have our candidates, we are going to postpone the meeting, and we will send out the second notice at a later date, scheduling it for a date that we feel is safe for the residents in compliance with our state and local mandates or directives or recommendations, I guess, depending on what the language is for your local municipality. But otherwise freezing what you've done so far. So if you have your candidates that got their name on time, you're not opening up again for people to resubmit their name. You're basically saying, these are the people that got their name in on time, and when we feel like it's proper, we will send out that second notice with the ballot and letting you know who's able to be elected. And that's what some of our communities have done. The thing with that, though, is, and Jim, I think you had touched on it before, and I was looking at some of the questions, so if I addressed something you already did, I apologize, but we don't think that it's proper to have a completely virtual membership meeting because of the fact that there needs to be a physical location, and it's really the ability for the membership to vote. So where the board is able to vote, and there's already statutory rights to vote via telephone or video conferencing or FaceTime, and that's always been the case regardless of whether or not it's an emergency, you don't have that ability to have a completely virtual member meeting where you're basically preventing somebody from showing up. Let's say, I mean, I'm as guilty as the next person. I live in an HOA and I forget to submit my ballot. If I want to, I should be able to show up and cast that ballot as of the date of the meeting. If you cut off that ability and have that location, that could become difficult. You might have an owner that objects to the election results. So that's where some communities are either then they're just postponing it because they want to have a place, a physical location, and we don't see anything in the statute that allows you to say, for example, if the statute allowed it, you could do something where the second notice goes out and says, if you want your vote to count, you need to either sign up for electronic voting if your community has done that, or submit your ballot or your proxy in advance, because there will be no way for you to do it on the date of the meeting. There's nothing allowing communities to do that right now, and that's where we're more hesitant, and it could be subject to challenge your election results if you were to try to do that, as opposed to postponing it to a later date and then deciding, at that time then to conduct your election. We did have one community to say, well, what if we don't have more candidates than there are vacancies, which is a way on the condo context or co-op, or if your HOA has allowed it, where you don't have to have an election, and that on the condo context, I can't remember if it's in the co-ops or not, where it basically says that that those members that have put their name in are deemed to be directors as of the adjournment of the meeting. And so maybe what you can do in that situation is you have a couple of people like the manager and a board member show up and say, we're going to call the meeting to order. We have nothing else on the agenda but the election. And you ask people not to come in and not participate because there's no votes that are being cast, because there's no election, because you don't have more candidates. And that we're immediately going to attempt to call the meeting to order. There's no quorum, but we notice that there are 3 candidates running for 3 spots. Therefore, they are deemed to be on the board as of today. And now we are going to adjourn the meeting because there's no other further business. That's one way that you could do it if you wanted to have those new directors start as of the date that your annual meeting was going to take place, as opposed to waiting a couple months. So talk with your legal counsel about that. It's a kind of an unprecedented time that we're in right now, but I did have that question come up for one of our communities as a way of, if you really want to try to have, especially if you're not going to have an election, you know that there are 3 people running for 3 spots and you just want to have them seated. That could be a way to do it. But again, talk with your attorney, because it depends on your documents and what your election process is, and making sure that it's in line with the Florida statutes on it.
Particularly for HOAs, where your election procedures can be, very different. You have a lot of flexibility, whereas condos and co-ops, your election procedures are statutorily mandated and supplemented by administrative regulation.
HOA elections are very much like the Wild Wild West, and it's very much document specific, and it's not uncommon for communities to adopt an election procedure by practice that's different than what their documents allow, and that's what we want to make sure that they're in a line. And so, especially for HOAs, if you're going to do something like that, talk with your legal counsel. If we represent your community, we're of course happy to help, or if you want to give us a call, but talk with your attorney about that. So cleaning and maintenance schedules, we've talked about some of this already. The board has discretion. So one thing that I've mentioned before is, if you choose as a community to increase your cleaning schedule or your maintenance schedule because you're keeping some of the amenities open, I think that is within your authority. You obviously already have the ability to expend those funds. And if you're worried about going over budget, this is what I teach when I teach a board certification class. The budget is meant to be an estimate of expenses for the year. It's not a cap on what you can spend for something. If it's something that lawfully comes up that you feel like, well, obviously we didn't expect a pandemic to happen and to have to increase our cleaning schedule for 3 months, and we went over budget on your cleaning or your janitorial or whatever it is, I wouldn't let that stop you if you chose to do it. Now, I also wouldn't advertise that to the membership that you are doing that. Again, we're broken records a little bit here, but I wouldn't necessarily communicate that to say, hey, we're committed to providing for your health, safety, and welfare, and in connection with that, we are increasing our cleaning schedule. I wouldn't do that. I would just, if you want to contract with them, I think it's a proper expense. So do I think you have the ability to do that? Yes, but the method of communication is another thing, nor do I think you necessarily have to. But I think it's certainly defensible if you chose to do it. And I would likely find it would be very difficult to argue with the association increasing its cleaning schedule and somebody charging that it's not within your authority as a board. Again, second bullet point, balancing the line between administering duties under the governing documents and warranting the safety of residents. And then again, considering disclaimer language and signs. So I know we've had some questions in the chat, and I'll go through and probably dismiss or answer, show that we've answered that later. Generally speaking, if you had some disclaimer language, it would be something, if you are keeping it open, you'd want to say something like, you're using this at your own risk. The association does not provide for any the health, safety, and welfare by way of increased cleaning, or we are not able to prevent the spread of this. You're strongly recommended to follow the directives of federal, state, and local municipalities, and maybe have links to that. But again, for anything that you're communicating, and I know it sounds like attorneys that we're trying to have you go to your attorney for everything, but when you're putting something in writing and you're putting your sign in place, contact your attorney. We've been doing this for our clients, and we can answer it fairly quickly, but we just want to make sure you have the right language so you're not saying something that could be used against you later on.
Yeah, and again, what we're looking for is that language that can be argued by a personal injury attorney to deem you have undertaken a duty, or we're committed to ensuring health and safety. Try not to say things like that. You can get your point and information across without saying that sort of extra stuff.
And I know we have a lot of people in here. If you are a personal injury attorney, please don't take that personally. I have a lot of personal injury attorneys that are my friends. Okay. Shelter-in-place orders. Be mindful of that. The question that we have, and then kind of some extensions of this, are what can we do? We've touched on already. The association and the manager, you are not meant to carry out the executive orders in terms of that's law enforcement. that's where you need to contact them. There may be certain ways from a civil standpoint, like I said, if you have rules in place or anything that might be a violation of your document, the best thing that you can do is continue to provide them with information and where they can obtain information on this and what recommendations are, but walking that fine line between recommending that they do something versus ordering that they do something. Something that's come up more recently, I mean, we're up here in St. Johns County, and actually this went national where they showed Duval County closed down their beaches, I think at least a week before St. Johns County did. And if you saw a picture, you could see an overhead shot of the Duval beaches where they had police patrolling it on their ATVs. And then you had the St. Johns County line where you had a whole line of people there. And that was spread around nationally of the difference between how counties are handling this and the problems with people not abiding by social distancing. I don't think it's a coincidence that St. Johns County, within about, I think, 2 or 3 hours after that went viral, announced, I think it was on the weekend even, that they were effectively closing any of the public access or any of the beach access to the residents or anybody in the county. And so the question then comes into, well, what are we required to do? Are we required to prevent people if you're in an ocean front, or I know we have, this is on, if you're on the Gulf side, you know, obviously on the Gulf side here, are you required to prevent people from accessing the beach if you have there or some type of waterfront that might be closed down? I don't know that you have a duty to do that. Now, could you choose to do that, or at least notify people that based upon directive, it's our interpretation that we are preventing access? I think that's certainly defensible, but I don't think that it's your job to carry out what the mandate is from the county. Jim, what did you say before? Give the kind of the absurd example, right, of the signage, for example.
Yeah, right. So in terms of who has the obligation to enforce law? Well, if you have this executive order, it's a law like anything else. So just like you don't have to post signs saying don't murder people, right? That's illegal to do that. I don't necessarily think that you have to post signs advising people of what other law happens to be as well. So I think you have some latitude. I don't think you have an obligation to enforce law. I believe, we have an executive branch that has that obligation, right? So call law enforcement. And in terms of how you choose to close amenities, I mean, maybe if it's a beach walkover situation, could you put up a little rope? Sure. Could you put up a sign instead? Sure. Do you have to do any of that? Probably not. I think, again, the obligation to enforce the law is law enforcement's obligation. So consider contacting them if you believe that a law, including an executive order, is being violated.
Yeah. There's going to be a lot that goes with this. It's going to depend a lot on, from what we've seen, there hasn't been a large scale, as opposed to other states, from a state standpoint, a shelter in place order. I wouldn't be surprised if that comes out based on what we've seen in the news, depending on what you look at and what the testing is and how Florida is doing right now. So right now it's kind of on the local counties or the municipalities issuing these orders. So be especially mindful of that. And then we can work with your legal counsel to synthesize that with anything that may come out from the state level. There was a good question before. I want to make sure that I address it because I think it comes up here, where somebody said that there's nothing from a county or a state level, but that the sheriff is telling people not to use their pools. Well, that's a difficult thing of whether or not that's enforceable. I think this is from the question from about 20 minutes ago or so. However, the sheriff issued an order of not using the pools conflicting. Which level do we listen to? Again, that's where you want to take a look at where is that sheriff. They have to be relying on something. The sheriff typically they're tasked with carrying out the mandates from from their local municipality, from the government, depending on what you're dealing with. So I want to see what they're relying on before I would say that it would apply for your community. So yeah.
Whether a sheriff, a law enforcement agency has the ability to, give that kind of directive or make that kind of order is certainly questionable. But, it's something that will require us to look at. Maybe there's been a delegation of certain authority for your law enforcement agency in your jurisdiction to make that kind of call. So it's tough to answer, in a broad and general sense. But it's possible, and you may have grounds to challenge that position that you might be receiving from local law enforcement potentially.
And I've seen too, just a couple of questions because I want to make sure we address it, is if you have bathrooms or hard surfaces or anything like that, when you're talking about, again, it's the same thing that if you're already cleaning those, if you choose to increase your cleaning, I think that's fine. If you're required to shut those down, it would depend on the nature of the type of community that you have. We want to look at that, or if you're required to keep them open for that matter. But kind of the repeat answer that you're hearing from us is, I would be careful about, if you are increasing your cleaning, that you're notifying your membership of that, or that you're warning that you're doing that to prevent the spread. You don't want to try to say that to your membership, because if you fail in that and somebody gets sick and they'll somehow point, well, I was around the clubhouse and I used the bathroom a couple times, they may try to use that against us. So again, just be mindful of all that. And I know it's not a black and white answer, but it's the best that we can do on a case-by-case basis right now. I'm going to go through, this is our last slide, and then I'll be happy. I'm going to go through the rest of we have a lot of good questions. I think we've answered some of them. So the long-term effects of this, from assessments and financial difficulties. We touched on this earlier, and I cited to the unemployment filings that we had. I think it was 3.3 million was the report that came out last week. It's a huge uptick. If you look at a chart, but I think that whatever the frequency is, the last time they released those numbers, it was 250,000, I think, unemployment applications, and it jumped up to 3.3 million for the next reporting. What that means is, obviously, and especially certain industries are getting hit harder more than others. The service industry, restaurants, hotels, tourism, depending on, all of that is very difficult. For our office is running as normal because we're able to work remotely. Not every business is able to do that. So you're going to have residents living in your community that are going to have problems with, I'm sure, paying their dues. And I don't think it'll be a coincidence if you have, well, April 1st is probably the start of a new quarter for most of you, how you determine your quarterly assessments or monthly assessments, that you'll see an uptick of people not making their dues starting April 1st or May 1st or something like that as this starts to roll out. The biggest thing that we would advise against, though, is any type of blanket determination from the association that you are deferring payment of assessments or that you're deferring late fees or interest. I'd be careful about doing that, just because you have some issues that are going to come up. If there's a foreclosure that happens and there's a third-party purchaser or a bank that takes title and there's some liability to pay those amounts back, we don't want to make it seem like we've waived our ability to collect those if we can rightfully collect that from a new owner. The main thing that I would recommend doing right now is, if you have an owner that contacts you, take it on a case-by-case basis and look at the hardship for it. And if there is enough of that, then you can determine as a board how you're going to be addressing it. But there is a statutory provision that says you're not allowed as an association to waive collection of assessments from an owner. You can't really waive it. Now, there are very limited instances. The only time that we've really gotten into that, when we've advised our clients from a collection standpoint, is if somebody is going through a short sale and they're willing to pay $5,000, and if you don't accept it, then the bank's going to foreclose and the bank only has to pay $1,000. And the $5,000 might be a cut of their assessments, but at least it's better than getting $1,000. I think the board has discretion in that standpoint. But aside from that, if it's not dealing with somebody imminently losing their home and you have to make a decision on the amount and it's because they've lost their job or something, I wouldn't make a blanket order on this. I would treat it on a case by case. And if it comes up that you have a lot of delinquencies, you may have a process for it where maybe even some type of rule is put in place. I mean, I had one on Monday, somebody asked us a question of, if we're going to allow deferment or waiver of late fees and interest, should we require verification of loss of employment? I mean, that could be a way to handle it. But I would advise against, I know and we all want to be empathetic, of course, but we're worried about waiving your ability to collect assessments from the current owner or from, future owners that might come in that would have liability to pay those, depending on a communication that goes out proactively from the association. So I would consider it business as usual. And the reason why is because you have vendors that you work with. You probably have a lot of contracts in place that are recurring, or you have a monthly service or something from landscapers, or obviously you've got your insurance premiums that are going to come up. You have your management contracts. Lots of things are in a recurring nature that those vendors aren't going to stop to ask, they're going to expect to be paid for the work that they've done. And the way that you pay them is to make sure you have money from assessments to then pay your the contracts that you have in place. So that doesn't stop throughout all this, unfortunately. And so just be very careful about communicating that. We did receive something through CAI just yesterday where the Tom Skiba, who's the CEO of CAI, which is a nonprofit international organization that our firm is part of, I know Vesta is part of, where it involves homeowners and management companies and business partners that work with associations. It's this big 40,000 member international organization. They put out a recommendation to communities, or not a recommendation, a request to communities to defer foreclosures, I think until June 1st or until a later date. And what I think that is in response to is there is a bill that's been proposed in Congress that's gone through at least, or it's going to go up to committee, if I remember right, which is trying to stall the collection of consumer debts, which association debts have been deemed to be consumer debts. And so that would be a law that would prevent not only associations, but credit card companies, any other consumer debt that could be collected, to put a moratorium on that. That will be really difficult for your association if you're unable to collect and take action to collect debts from your owners if they stop paying assessments. So what I think that CAI request comes from is to show, hey, we're trying to police our industry by recommending that they at least hold off on foreclosures, but they still be allowed to send out letters to record claims of lien and to at least take certain steps up until the foreclosure aspect. And so we've seen that, but as of right now, there is not a moratorium on collections. And there is, from a mortgage foreclosure standpoint, I believe there's a moratorium on sales, if I remember right, from setting sales.
For federally insured, your Freddie Mac, your Fannie Mac. If I can say any one of them correctly, your FHA, right, Freddie Mac, Fannie Mae, VA, those kind of things, where you have some kind of government insurance, secondary mortgage insurance.
So that's all that's in place right now. But again, this assessment issue is going to be the long-term impact of this. I think hopefully we're all up and running, maybe, well, who knows, but maybe 2 or 3 months from now where things get a little bit more normal, who knows. But you're going to see the economic impact of it with assessments not being paid. And looking back, if you've been on your board or if you live in a community that was more like from 2008 through 2012 or 13, when we finally started to especially rebound, where we were in difficult financial times with delinquencies, we might see that again. And the best thing that you can do as a community is understand it, look at what your documents allow you to do from a collection standpoint, have a collection policy in place, and working with your management company and your attorney. And then obviously be mindful and empathetic, but not to the effect that if some owners stop paying, it's going to affect the rest of your owners because those bills have to be paid and services aren't going to be provided. And that's the difficulty with all this. Touching on this from an assessment and financial standpoint, one thing I think is really important is that the emergency powers in the statute do not give you the ability to use reserves for operating. If you do have delinquencies that come up and you have a healthy reserve balance and you don't have any reserve expenditures coming up for a while, the statute, the emergency powers do not give you the ability to use reserves to pay for operating expenses. The only way that you can do that right now is to schedule a membership meeting, which again is difficult under the circumstances because nobody wants to meet in person, but maybe 3 months from now or whatever the time period is that it's safer to have, maybe deemed to be safer to have a meeting again, is you can have a vote to waive or reduce the reserves if you were to pass an amended budget, or if you were to use the reserves for other than their intended purposes. That requires majority approval at a meeting where a quorum is met. So it's not a majority of your entire membership. It's as long as you make quorum, it's a majority of those people present in person or by proxy can vote to use the reserves for other than their intended purposes. So that's an important thing right now if you're a community that was looking to use your reserves for operating expenses. Again, could they change the statute in the future to allow for this? I could see that potentially being a power, but obviously that could be subject to abuse. There's a reason why those safeguards are in place, is to prevent the board, if there are some quote unquote rogue board members that take control of the board and decide to use money that was otherwise planned for future necessary expenditures like, roofing or painting or pavement or your pool, anything $10,000 more. There's a reason why that money has to be set aside. And as of right now, there's no flexibility for that. We're still uncertain as to kind of another thing. Talk with your banker too, to see if all of the new SBA loans that are coming out, whether or not your community association applies for that. We're not sure yet how that's going to apply. There's different programs that are available. There's one that's the biggest one right now, which is the CARES Act, which has the Paycheck Protection Program. I'm not sure, unless you're a large community that has employees, whether or not that would be available for you, but there may be other type of new products available for you from a small business SBA loan standpoint that you should talk to your lender and work with your manager about if that's a possibility for you to help kind of stem, any difficulties you have. So that's one thing, use your people that you work with, your professionals that you work with, and reach out to them and say, what are our options right now? What options do we have? What can we apply for? And that's why it's so important to use good people that know and what's going on in the industry that they can properly advise you of that. So Jim, do you have anything else on the assessment or the financial side?
Well, maybe just to tie a quick bow, what we're suggesting is there's room to be empathetic to your members, but what we don't want to do is send out a communication that could be used against us later on by another financial institution that acquires a unit in your community or a home in your community. You know, there's room for empathy while also complying with your fiduciary obligation to your members to, you know, collect assessments that are owed to the association. Again, plenty of room for empathy. We're suggesting not sending out a general blanket communication suspending the application of late fees or interest. There's going to be a time period anyway, whether it's a court imposing, a government entity imposing a moratorium on your ability to foreclose or whatever. There will be a period of time to try to work with people who experienced a financial hardship, and there will be some latitude you will have there to accommodate people who have had hardships. We don't want to paint too broad of a brush and give financial institutions who might ultimately foreclose on properties in your community the benefit of what you're trying to do to help, you know, your average Joe citizens with a hardship they might experience. So right now, we'd caution against sending blanket communications like that. Let's consider any people who are having financial hardships on a case-by-case basis on the back end once we start seeing how this economically affects people. There will be room for empathy, we promise.
Yeah. So I'm going to go through some of these questions. We'll take these for as long as we can, understanding everybody's time, and thank you all for attending, and please stay on because I think we have some good questions on this, but if we can't answer them, please reach out through your manager and talk with your legal counsel if it requires it. But this is a good question that actually was asked at the beginning, which was, what is the limit as a resident, as a human being, if it's possible that a guard is contaminated but the service provider does not act with any other consistency other than safeguarding their business? So I think the question is, if you have security services and they're continuing to man the gate, but they have a guard that might be contaminated and they're continuing to send them out. That's an interesting question from a contractual standpoint of whether or not you can find them to be potentially in default of the contract. I would guess that most contracts don't contemplate specifically if there's a pandemic and they're bringing people to the work site that are unsafe for your residents. But I would strongly recommend that you contact the company to let them know of your concerns. There's a difference between, of course, what you can do contractually versus it not being good for business. If it's being made known that this company is sending people to work that are sick, obviously you can contact the local news, or if you're working with your management company, typically management companies have a good pool of vendors and they make recommendations to other clients. Those companies do not want to have for example, for Vesta to go and say, hey, I normally would have recommended this company, but during this outbreak, they were sending sick people here. I wouldn't recommend that you use them anymore. So use your tools that you have and contact them, but contractually speaking, whether or not there's a way to get out of your contract or to find them in default, it would depend on the language you would need to talk to your attorney about that.
Contract says we have to furnish a guard, doesn't say it has to be a healthy one.
Right, yeah, so that's a good question though. I think the next question is, how do you describe your efforts? I think again, communication is key in how you're crafting this. Make sure you're walking the line of saying we're trying to take actions that are in line with what's being recommended, and also understanding your rights as a homeowner, and this decision is not made easily. We've tried to give this a lot of thought, and we're trying to do this based upon the directive or what we see as our guidance from our state and local officials on what we should be doing here. I think that's the best way. It's just how you're communicating that to your owners. Are associations able to deny rental properties from renting during this pandemic? How is the state order applying that's in effect right now? It depends on the type of community that you have. I've seen some communities that have guards that check in guests, and they only allow access, of course, if you're a resident or if you're a guest or if you're a registered tenant. I've seen some communities that have denied that based upon the state order. The question then, those tenants may argue whether or not that order, and Jim has talked about this, there's a whole other thing of whether or not these orders are constitutional, but assuming that's correct, I would talk with your attorney if you're deciding whether or not to deny people at the gates, for example, if they have a valid lease, and how that lines up with the order and what liability the association may have.
And that, and also what authority you have in your governing documents to regulate rentals and tenants to that in the first instance, right? So it's going to be a little bit governing document dependent in terms of what authority you have to regulate, rentals. But we do have, depending on what your documents would provide, we would have some suggestions in how to handle rentals. And
the other, if we do think though, if it is a violation or if they do it and you can't physically prevent them, I was talking to a manager yesterday about this. She said, Ed, should I be calling Johnny Law? And I said, there is a part of the order that says that I think it's a second-degree misdemeanor from the standpoint if a rental agency, I think, is advertising it in violation. I don't know if they still carry out the rentals and if owners are renting it. what the criminal penalties are, but I would contact law enforcement and say, we have somebody here that seems to be a clear violation of the executive order that came out, and then give that information. I wouldn't do anything further than that in terms of physically preventing them if you feel like you couldn't prevent them from getting to the property in the first place, I guess. So again, it goes back to what your documents allow you to do, but again, using law enforcement if it's something that they should be enforcing. What should the association do if some residents aren't practicing social distancing? Again, that more than anything, like if you have a larger common area that it's really difficult, like I'm trying to think of like an open field or something, like not many communities would necessarily have that, but more of an open space that's difficult to actually shut down by way of locking the gates or something like that. There's little that you can do except try to continue to send out recommendations to your owners. You know, what's up to date on recommendations from the CDC or, you know, the state or federal level. But aside from that, there's not much you can do from that standpoint.
Yeah, communicate. If you have something closed, communicate that it's closed. If people aren't complying, again, consider contacting law enforcement.
I think I answered this question. Should we place a sign that says enter at your own risk? I think if you are going to keep it open, I think it would be helpful to have the right language in there about if it is open, information they can have about the spread of it, that they do so at their own risk. So I would say if you are keeping it open, I think it would not hurt, I think, to put a sign up like that. I don't know that you have to put a sign up though either.
Right. It's to try to mitigate the potential for liability or at least reduce the value of the claim. I would probably suggest a little bit beefier language, because if I were a personal injury attorney on the other side of that, I'd say enter at your own risk. Well, I thought you meant, you know, I might trip over something, right? A property boundary or something like that. I didn't realize that you weren't taking precautions with respect to this virus. So is that enough language? I don't know. I'd probably recommend a little something beefier than that.
There's a good question here about the conflict again. I think we answered this because I know with Pinellas County with the sheriff and what their directive is. And I think we answered that, which is you got to talk with your manager and your attorney and try to look through and see what applies to us. What do we have to do depending on what your board wants to do on it? There's no black or white answer. The closest thing that I've seen to it was, again, what I mentioned in Miami, where they specifically said that they were shutting down all pools, spas, fitness centers, I believe, for everything except for if you have it for your single family residence or a townhome that might have a hot tub or something like that. So again, you have to take everything and try to see how that applies to your community, but it just is going to depend on what your local government has done versus the state versus the federal government. And aside from that, we just need to take a look at that specifically. There's a question here about a community that has an SBA loan that you're required to pay every month. Talk with your banker. I know that there are some things that for existing loans that there may be some deferments available. I'm not saying that that's actually the case. I know that there are different programs. So talk with your bank that you're working with and see, they should be able to provide you with guidance. Most banks are looking into this because they're the ones administering the loans under the CARES Act, and they're kind of being deputized, is what I've been calling it, from the SBA. So talk with them and see what your obligations are. But if people aren't able to pay, I don't know what the requirement is, if you're required to put up collateral or as part of the loan, or if they may have access to your reserves. But it's a good question. If people stop paying their assessments, I would talk with your attorney and your management company as to what your collection policy is. What's the best way to try to take steps that you're allowed to take and utilize your tools to try to ensure collection as best as possible during these times. And if you're unable to do that, again, then maybe if you have reserves, you could take that vote to utilize reserves or try to obtain an additional loan. I know though that it's difficult to get a loan if people aren't paying their assessments because they want to see what your delinquency rate is. So there's different tools that you have, but I think you need to work through them to see what your best option is.
Yeah, if you're that small of a community and you're going to have that kind of financial trouble, you're going to need to unfortunately be coordinating with, you know, management and your legal counsel to see what your, and also financial institutions to see what your financing options are. Yeah. Worst case scenario, you might be looking at a bankruptcy. In which case, you know, you'd have a bankruptcy trustee come in and try to collect assessments from, you know, any debts that are owed to the association. But you want to try to avoid that, obviously.
Quick question regarding request to check out weights, dumbbells, and exercise equipment. Are we within our rights to deny this request? I'd say yes. It's association property. If you've already closed it down, yes, you're absolutely within your right to deny that request. Let's see. This question, it looks like it's with the application to buy a unit, which is different from the directive of the blackout period for rentals and everything. This is one that's kind of beyond the scope that we could answer, I think, during this webinar, you know, with any specificity. I think we would need to look at your governing documents for your approval powers, what you should be doing, but there's a question of, does the association or the Vesta employee have any responsibility to provide a key or open the unit for inspection? You know, that goes towards, a lot of times if you're in a condo, you may have a key for the purpose of accessing a unit if there may be damage to the unit or the common elements. But if you have a responsibility to provide a key, I don't know that that's the case. We'd have to take a look at that, but I don't know that there's a legal responsibility if an owner asks you to provide it. I mean, so again, that's a little bit beyond the scope, and I'm sorry we couldn't answer that in more specificity, but I think it requires a little bit more look at your documents in your specific situation. Let's see. We talked about this for communication about people that have been diagnosed. Don't name names. That would be our advice, to not name names unless they give you specific written permission to do so. Jim, this is like a Jim question. Is there a component of the Fair Housing Act that will require the pool to stay open for rehabilitation or therapy when residents request it, as opposed to the directives from a health standpoint?
So as a disclaimer, you know, obviously we're getting a little bit more specific into some legal questions, and I'm not, you know, on Westlaw as we sit here. So this is more general, you know, my general perception without having performed that research. In that situation, if you close it for everyone, then you're not discriminating against anyone with a disability, right? The situation where you run into problems is where someone with a disability or handicapped, as it's specifically defined under the Fair Housing Act, is placed in a different position than someone who is not handicapped. And if you close it for everyone, that's not, in my opinion, that's not discriminating against persons with, you know, with handicaps. So I think you should be okay there. Now, is that going to stop someone from suing or filing a complaint with either the Florida Commission on Human Relations, which is a state agency, or HUD, and claiming that's an act of discrimination? Well, unfortunately, it's, depending on your perspective, it's free to file that complaint. They can drag you through the investigative process, and you may or may not have insurance coverage for that, depending on the quality of your policy, to help you with those defense costs. So my general impression is that I don't think you should be held liable for discriminating in that context, because in fact you wouldn't be discriminating, right? Yeah. Everyone's being treated the same.
Right,
no one can use it.
Right. Yeah. This kind of went back to the other question about what about if there's real estate open houses or private showings for sale? Can the board prohibit? What are the liabilities if you do not allow showings? It's a difficult thing. If it's a house showing and they just need to check in through the community, this is more of a financial impact directly on owners. I could see potential liability if you prohibit these, because if they say, hey, you kept me from being able to show my house, and I would, it's a direct financial impact on me because it's taking longer for me to sell my house. Now, from a proof standpoint, it's tough for that owner to say they would have gotten an offer at that showing versus if they got an offer 2 weeks later or through a virtual showing or something like that. But it's a difficult thing. My gut reaction to that, and Jim, let me know if you disagree, my gut reaction would be to allow them in, but to let them know if you have closed the amenities or that you're recommending social distancing, or which amenities are closed if they're trying to tour, or to please ask them to stay in their car or something like that. Because if they're going into a home, that's pretty much between them and the homeowner for anything that could be from a liability standpoint from spreading. But if you have amenities that are closed, let them know that. Please ask them to try to stay within their car because of obviously everything that's going on with it. But I'd be hesitant to keep people from going in for open houses. It's a very good question, but that would be my gut reaction to it.
Yeah, I agree. And you know, some of it's going to be governing document dependent, specifically in an HOA context. So, you know, what authority you have to keep people out like that according to your governing documents is going to be a question. You're likely going to have a greater degree of latitude with respect to the common areas and facilities, which you directly own and maintain. But prohibiting someone from actually seeing a house, I think it's going to be a little bit, you know, more difficult to do that. But from a practical standpoint, you know, real estate agents are making accommodations for our current situation. And so a lot of times, you know, I've seen some posting on social media that they're doing virtual tours where it's just one real estate agent going in the home and just doing like a video tour for people who are looking at homes remotely. So some are taking some, what I consider to be smart practical steps, and hopefully they will in your community as well. But generally in an HOA context, I agree with what Ed said. You probably don't have that much authority to be able to prohibit it from actually looking at houses and things like that.
So I'm going to try to answer. We have about 20 more questions here, and I'll try to answer a couple more if that's okay, just because we're getting past. And I think they're great questions, but I also want to be able to have this wrap up for everybody too. Real quick, use of the elevator. I would be, again, post signs, try to, if possible, for people to only use the elevator one at a time, but I wouldn't, there's nothing else that you can really do if people are using it at the same time. Elevators go into accessibility issues, especially with people with disabilities and everything. So aside from that, maybe posting a sign But again, that you're not there wiping down the buttons after every time you use the elevator, for example. I mean, or that you're prohibiting people from using it more than at one time. I think people just need to be smart, and most people will say, hey, I'll get the next one. Hopefully that's the case. But aside from that, I'm not sure what else the association can do on it. There's a question about children using the condominium parking lot, riding around their bikes because they don't really have anywhere else to go. That again, I think that that's an easier thing because there's a clear liability there potentially of people driving their cars in. And I think that it's within the purview of the association to regulate, you know, bikes being driven around by kids and being a safety issue.
Yeah, let me add one qualifier to that. If you try to regulate people on bicycles, don't direct your rules toward children.
Children, just anybody, right?
That's a Fair Housing Act issue. So, you know, try not to target just kids or people of certain ages. If you don't want any bikes in the common areas, then try to regulate no bikes in the common areas, even if for only a temporary period of time. You know, are there some counter arguments to that? Well, we have easements for ingress and egress, and this is the parking lot, and we have an ingress and egress easement over this area, so you can't do that. Potentially, sure, but should you, could you consider trying to make that regulation? Yes. If you do so, though, again, don't target children specifically. Target anybody on bikes.
Yeah. Let's see, just going through a couple more questions. There's a question about the agenda for your board meeting. Do you advise that meetings required list all items on the agenda and eliminate the category of others so that only business items identified can be discussed and voted on by the board? You want to be as specific as possible when you're posting your agenda to make it not seem like you're hiding something from them. I mean, I've seen that with some boards where they'll put other and then they'll bring something up that wasn't specific on the agenda that people didn't realize that the board was going to be talking about. So if you know of something that's going to be addressed, make sure you put it on the agenda if you're required to post the notice in the agenda. There's a difference between the condos, which you do have to provide the notice in the agenda, versus HOAs, where it's not as clear that an agenda is required. It's not as specific. But if you are posting it, which most communities do, try to put what you know what you're going to be talking about and still have the other. So if something comes up, or if there's something between the posting and when the meeting happens that you need to address, you can add that to the agenda and you're not trying to hide anything. That's the biggest thing, is you don't want owners to think that you're trying to discuss something that you are hiding from them so they don't show up to the meeting that they otherwise know they might be, have some concern over.
Yeah, and there's that statute in the Condominium Act, it may be in the Cooperative Act as well, but it basically says an item not on the agenda, again, only talking about condos, may be taken up by the board on an emergency basis by a vote of a majority plus one of the directors, and then later ratified at a subsequent meeting. So there is a process to deal with things that aren't specifically on your agenda in the condo context.
Right. Going back to the meetings, if you collected all your proxies for a March meeting that obviously we're just through March and you weren't able to have it, can you conduct the meeting virtually? Again, the idea, if you've conducted proxies, there may still be people that would want to show up and vote in person if there's going to be an election. So the fact that you can't have a physical location, we've been advising against having a virtual only meeting. I would just postpone it and say, we've got proxies. We're postponing it to a later date. If you haven't already submitted your proxy, please feel free to do so. But we're going to let you know when we're going to have the meeting so that you can show up and actually cast your vote in person if you haven't sent in a proxy already.
Yeah, I guess maybe the only potential caveat I can see there is if everyone in your community consented to online, which the likelihood that 100% of your community consented to online, electronic voting under the recently adopted statutes is probably limited. If you have a small community, perhaps, but otherwise, the other concern we have is technically in a condo context, cooperative possibly as well. Your ballots have to be counted by that committee, and there are lots of arbitration decisions where the committee went to another room somewhere else and the arbitrators didn't like it, right?
Yeah.
So the ballots have to be opened and counted in the presence of the membership, which is also one of our main concerns trying to conduct an election at this time.
Another quick question about renters after March 28th. Does this include members of the owner's extended family who did not pay rent? I believe it just says short-term rentals, and he uses the term rentals. So if they can show that they're extended family, I think that would fall under owners are able to provide guests. Now, if you're trying to shut down access and locking down the community against any renters or guests, that requires more analysis of your documents and whether or not, the potential pitfalls from a liability standpoint. But for this question, whether or not that order affects extended family members, I don't think that it does. I think that if you're just trying to use that solely, you would still have to allow those extended family members in. Procedures for committees, do they have to post meetings and invite the membership? It depends on if you're a condo or HOA. Condo, all committees have to have notice meetings just like in the same manner as board meetings are. For HOAs, it's document specific. By statute, HOA committee meetings that involve architectural decisions or a committee that makes a final determination for disbursement of funds have to be noticed, just like a board meeting. But other committees aren't unless the bylaws or the documents require it. So that's a document specific question. Let me see. A resident rents his unit by the week during non-season and claims that each visitor is a relative and not paying rent. He evades the bed taxes. If it's from NYC, they would need to self-quarantine for 14 days. Can we limit visitors and relatives from visiting? Again, another specific question, depends on what authority you have in your documents versus what the directive is, and if you should be physically preventing people or not. I would want you to talk with your legal counsel about that and get a written opinion. One thing is when you get a written opinion from your attorney, and my partner Mike says this, and Mike, if you're listening right now, I know he was going to attend, it's like you're buying insurance. So I'd rather get that in writing from your attorney. It's something that we can't do. We'd have to look at the specifics with your documents, but it's a very good question though as to what authority you may have. What occurs if during these times that we don't have owners that want to serve either the correct number or no one wants to be part of this new environment? I think that's a question regarding serving on the board. Encourage people, please, we need you as volunteers, because what happens if you don't have somebody to run from the board? Technically, a member can petition to have a receiver appointed from the state, and that receiver gets paid, and that's going to result in an increase in dues, and somebody that doesn't live in your community for making decisions for you guys. So try to keep people serving as best as possible. If you've got a good management company, and of course, if you're working with Vesta, Vesta is a great management company that they largely do a lot of what the board members individually would normally do if they were self-managed, but they still need to take direction from the board on certain things from a policy standpoint. So make sure that you get people that are committed to help, stay involved. And I know we have Jim coming on here. Jim, you'd probably say, please, we can only do so much as management. We can't make all the decisions for you. We still need to have residents that are willing to serve on their board and help make decisions for their communities.
Absolutely. And Ed, I know you, to be respectful for your time, this has been a great webinar. I think a lot of useful information. I hope everybody has gotten some good information from it. If you want to go through a couple of more questions, or if you want to go through all of them, it's your call. If your question doesn't get answered, by all means, reach out to your community association manager or local Vesta office, and we will try to get an answer back from Ed and Jim as quickly as possible.
Yeah. So let's see, I think we've talked about notice to use for the pool. That's a question. Late fees. That was a question that came up on the financial side. Just be considerate of late fees and interest are kind of your negotiating tool if you feel like you can resolve it. And that might be a soft cost waiver, in other words, to help somebody out, but I wouldn't provide a blanket position for the association right now on it. I would see how things go, and then if there's enough people, you can always meet as a board to discuss the issue that's going on and figure out how you're going to communicate that to your membership. Let's see. I just want to see if we've discussed some of these questions already. Would it be a bad idea to send out a communication stating that collection of assessments will continue? I think you almost just, I wouldn't even touch it from a yes or no. I would just say it's business as usual. And then if owners contact you individually, you can reply to them and see if they have a hardship, and you can try to respond in that way. But I wouldn't send something saying, hey, as a reminder, keep paying your assessments. I don't think you need to do that. That kind of, that's a given that they need to continue paying. There's a good question of, can the residents legally not pay their dues due to the fact they were not involved in the process of closing the amenities? This is a question that came up on Monday. The answer that I gave then, and there's a case on this that's kind of related to it that I would pinpoint, which is an owner stopped paying their assessments because there was water intrusion into their unit because they said that the board and the association wasn't properly maintaining the exterior of the condominium. Therefore, if they're not doing their job, I'm not going to pay the dues for what they should be doing. And the court said, no, you're not allowed to do that. You have to pay your dues. And if you feel like you have a cause of action against the association because they breached their duty, then you can file that as a counterclaim. So that would kind of answer this question of, just because amenities aren't being used, that doesn't mean that that you stop paying your assessments. Most of those bills still have to be paid for landscaping or your insurance premium, your management contract. If they've paid an attorney to give them legal advice, all those things have to be paid.
Yeah. Think about if everyone was able to take that position, then you never have the money to do anything because everyone's going to bicker about something that the association's done that they didn't have a decision, making part of, right? So it's a necessary sort of thing.
This is another question about communication about confirmed cases. Again, you want to be very careful, and I would want to have firsthand knowledge that there is a confirmed case. Even before this question is a good one that says, even if you don't name names, if you list the street or neighborhood, maybe, that may be more permissible, but I want to know that that was an actual confirmed case so that you still aren't able to have people pinpoint who this might be. And if it's not verified, you could have an issue from a liability standpoint from the association.
Just try to be accurate in your communication. If you're not absolutely positive, then don't indicate that you are. And the goal is to try not to pick people out individually. So try not to tie your geographic area down too narrowly to where people can say, oh, I bet it's John,
The next question comes, well, the entire complex was shut down with no meeting of the council and the board. Doesn't there have to be a vote of the membership to agree? That would not necessarily be a membership vote. That could be a board decision under the emergency powers that we stated, and it's typically the administration of the common areas is a board function rather than a membership vote. The question is whether or not there should have been a board vote versus an individual action made by the president. That could be a question, but for the most part, that's within the purview of the board and the president rather than it being a membership vote. There's nothing stating, unless it's document specific, which the statute does say that the emergency powers are trumped by if there is anything regarding emergency situations in your documents, then that may control, but most communities don't have that language in their documents, which means the statute controls, which means that it's really a board function. Let's see. And we have 9 questions left, Jim. If it's okay, I'll just try to answer them real quick. So we'll just leave it at this. If you can hold any other questions, or if you want to reach out to Vesta, and then we're happy, or if you want to reach out, we'll try to answer them later. But to answer these final questions here, can we ask our association to suspend any non-essential entries into our condo? Again, we've kind of talked about that before. That would be very document specific. Shutting down vendors, if we gave this example on Monday, if you shut down vendors or deliveries, what if somebody's receiving medical supplies? Or if it's something else that's necessary for them, that all of a sudden now you've got a medical situation where somebody says, you prevented this vendor from coming in, or it's an essential health service, and what if somebody died, for example? That's a very difficult thing then for preventing non-essential entries, and then how are you determining what's essential and what's not? That's more of a discussion that you really should have with your manager and your legal counsel. If you feel like there's a way that you can do it, and the way that you would do it, we want to be very careful about how that takes place. We've talked about, again, on the New York and on the leases that come in, it's document specific. Just be mindful of what the order is and contacting law enforcement if you feel like it's a violation of that. I'm not aware that you're required to leave the bathroom open if you leave the pool open, if you can leave the pool open but close the bathroom or not. That may depend on whether or not, I'm trying to think of like from an ADA standpoint, but that's more of a public accommodation thing from a disability standpoint than it is a requirement that you have a pool open from a private standpoint.
Yeah, and it could depend on the size of the community, because that could dictate the regulations that apply to your particular community association. You have the administrative agency, Florida Department of Health, that could potentially promulgate rules. So we're not really sure on that, whether you can leave. The question is whether you can leave the pool open but close the bathroom. And we're not exactly sure on that point.
Yeah. Let's see. Okay, so just the final questions here. Yes, we'll be having more webinars. We'll be happy if you'd like to attend. Please feel free to contact us. We'll make sure that you receive that, or contact Vesta. But we're doing this one specifically. What we anticipate as a firm, and I'll be happy to talk with Vesta about this, is more specific things for your community once we start operating as normal again. Collection issues, finding issues, enforcement issues, that sort of thing. But we do appreciate you attending this. Another question is, we haven't had a manager for over a month. What recourse do we have? I'm not sure if that question is if you have a contract but you haven't heard. I'm not sure. Reach out. If you do have a management contract, reach out to the office and discuss that with them. But aside from that, if you're self-managed, I would strongly look into getting a management company, because they will help you through this time, of course, and reach out to Vesta. They can help you with this. All right, well, that's what we have for everybody. We are recording this video. We're going to make it available. I know Vesta will be advertising how you can get a copy if you have a board member or somebody that couldn't attend. So thank you all again for attending. Jim, thank you very much for introducing us and for being a good leader for your region here and for being able to put this on.
Well, thank you guys for your time, and thank you for everybody to participate. Again, if you have questions, please feel free to reach out to your local Vesta office and your community manager, and we will get answers back to you as quickly as we can.
All right. Thanks, everyone. Have a good day. Stay safe.
All right. Take care, everybody.